Good afternoon again, Chair Bosin, members of the Judiciary Committee. I'm Hannah Murdoch, H-A-N-N-A-M-U-R-D-O-C-H. I'm the legislative aide to Senator Hunt, and I'm here today to introduce LB369 on her behalf. I already gave a little spiel about that at the beginning of the last bill, but if you're just tuning in, she sends her regrets that she is not here today while she's serving on the Government Committee for a very significant hearing today, and she thanks you all for being here. LB369 is a bill to change the age of medical consent in Nebraska from 19 to 18. A couple of years ago, I heard from a Lincoln doctor of physical therapy who told me about seeing many 18-year-old patients who have had to get parental consent for treatment. Some of those, she explained, are estranged from their parents or not in frequent contact with them for whatever reason. Most often, they're college kids living away from home, or maybe the parent is traveling or busy at work in meetings during a time-sensitive situation, and those patients are just unable to get the medical care they need without parental consent. I'm glad that this medical professional reached out to me because it is something I've heard about anecdotally. I know other legislators have tried changing this in the past, and I know that we're an outlier as a state with having our age of majority or legal adulthood set at 19, which causes problems in lots of areas of personal liberties for 18-year-olds when they're legally considered adults for a lot of federal purposes and in neighboring jurisdictions. I know there was what lawmakers at the time thought good reasoning for setting it at 19 in Nebraska, but now it's really outdated and unfair. The crux of the bill, LB369, is that it adds an exception to that 19-year-old age of majority law to say that when you're 18, you can make health care decisions for yourself, along with a growing list of other things lawmakers over the years have decided are acceptable things for 18-year-olds to do. Senator Moorfeld started working on this concept before me in response to University of Nebraska students who contacted him to talk about the difficulties they experienced in receiving needed health care in a timely manner while living on campus. In almost all cases except life-threatening emergencies, when providers have a duty to save a patient's life, parents or legal guardians have to be contacted or sign off on consent forms for providers to have permission to treat an 18-year-old patient. I looked through some of the history on past bills around this issue, and there were all kinds of stories about broken limbs, infections, and various illnesses that went untreated for too long while students attempted to get consent from their parents. There was one case where a student's parents lived in Japan and they had to suffer for hours until parental consent could be obtained and they could be treated. That's a more extreme example, but what would be a much more common case would be that you have a student come to UNL or UNO from Scottsbluff or elsewhere in the Panhandle or somewhere in the western part of the state, and they're here for college, but suddenly they get a really bad case of strep throat or something, and they can't get the antibiotics they need in order to function well enough to study and pass their exams without mom or dad signing off. This is especially egregious in cases of moderate or severe illness or injury, because we don't want young people to unnecessarily suffer or get worse, causing them to need more invasive or expensive treatments. But it's not just a barrier in these more serious situations. 18-year-olds living away from home can't even get basic preventive care like their flu shot or an annual exam without a parent providing consent. While it was students that led the charge on advocacy for this issue, I want to note that not everyone that is 18 goes to college. Many get jobs right out of high school or go to trade or tech school and move away from home, and there's just as much dignity, autonomy, and independence in any of those choices. It doesn't really matter, honestly, if they live at home or not. If they're 18 and they can sign a lease, register in the Selective Service, vote, file a lawsuit, take out a loan or a mortgage, get a tattoo, apply for a credit card, change their legal name, serve on a jury, why in the world do they need mom's permission to get a flu shot or antibiotics for an infection? It's a ridiculous nanny state thing that any young person that is verging on adulthood, whether our law sets that at 18 or 19, needs to have their access to health care gatekept by the government. In 2018, the legislature passed an exception to our age of majority law that allows for 18-year-olds to consent to mental health services. This was also largely driven by student advocacy efforts. If 18-year-olds can make their own decisions about mental health treatment, it's absurd that we would require them to get parental consent for physical health treatments. We in Nebraska are one of 3 states whose age of majority is older than 18, but the only state which does not allow 18-year-olds to make healthcare decisions. 18-year-olds in each of our surrounding states have been able to consent to medical treatment for some time, and the sky hasn't fallen. In fact, Lincoln or Omaha students can just drive across the border to Council Bluffs to get care right now if they want, though they shouldn't have to do that. Even Alabama, which is one of the others with a higher age of majority at 19, has a law that allows 14-year-olds to consent to health care. And I'll take a moment to explain the second component of the bill. Section 48285 provides that DHHS has the authority to determine appropriate medical and psychiatric services for youth in its care. However, there is no corresponding statutory authority for youth in custody of the Department of Corrections. The Department of Corrections operates one facility for minors in Nebraska, and that is the Nebraska Correctional Youth Facility in Omaha. For this population, there is no statutory authority for the department or this narrow population of youths to consent to their medical or mental health treatment, and their unique circumstances can really limit them from being able to obtain parental consent. This is important because there are times that a minor in custody will need somewhat urgent medical care. And if a parent or guardian cannot be easily or quickly located, important medical care might be delayed. They could have some serious injury or illness, and for the youth in this system, there's varying levels of parental involvement. Some may maintain contact with parents, but some may not at all. And so those that aren't able to get parental consent just have to go without treatment, and that can make them sicker or more hurt than they need to be the longer they wait for care. We also added an exception to the bill for use in DHHS custody after some extensive discussion with the department about this. The last time I brought the bill in 2023, that bill was LB369. That bill was advanced by the committee, but just didn't get a priority that year. Initially, I had hoped for and fought to include all youth or as many youth as possible because it seemed unfair to exclude system-involved youth. However, through more conversation with the department, I learned more about how including this population in the bill opens up much larger issues, and so for the sake of progress rather than perfection, I've agreed to exclude youth in the department's custody as a result of a juvenile court order. The major problem would be causing conflicts and potential major changes in the role and jurisdictions of the juvenile courts over this population. Allowing them to make their own decisions at 18 deprives the juvenile court of its authority over their cases, which jeopardizes their eligibility for foster care system involvement, DHHS-funded health care, and participation in things like the Bridge to Independence program. So it's quite complex and in effect could trigger some much more substantial changes across our courts and social services offered that I wasn't trying to get at with this bill at this time, though I'm certainly open to further discussions on that front. In looking at the legislative history around why we are one of the only states whose age of majority is not 18, it seems that way back in the early 70s, when there was a wave of states all lowering their ages of majority from 20 or 21 down to 18, Nebraska actually tried to lower ours from 18 to 20, but a compromise was made in that legislature to lower it to 19 instead of 18, because of concerns at that time about 18-year-olds being able to drink and being potentially vulnerable to financial predation. And since that time, we know the drinking age was federally raised to 21, and in Nebraska, we've added exceptions to our age of majority law to allow for 18-year-olds to engage in adult financial decisions like obtaining financing, mortgages, to own property, and various other things like that, and we haven't had a problem. So last time we got a question about costs. Who is responsible to pay for the services that the youth is consenting to? Normally, parents, as the legal adults, are considered the responsible party when a teen is on a parent's insurance. When young adults consent for medical services or check themselves into a hospital, they sign their own paperwork and agree to pay any amounts their insurance doesn't cover. Generally, parents would be responsible for their adult child's medical expenses only if they had signed an agreement with a medical provider to cover them. In other states, when a child reaches the age of majority and is no longer a minor, parents can no longer be held legally responsible for the young adult's bills. With LB369, if it is the young adult that is solely consenting to their medical care, they are also the party consenting to pay the costs associated with that care, not the parent. Of course, parents are free to work it out with their child if they want to assist with costs, and parents would have the option to remove a child from their insurance plan if they wish. To close, at age 18 in Nebraska, you can vote, go to war, consent to mental health care, consent to STD testing and treatment, own property, drive, own a firearm. LB369 is a bill that students have been asking us for years, and due to a quirky legislative history, Nebraska is way behind the times on this. 18-year-olds in every other state have this right, and there's nothing special or different about us and our young people that says we can't allow Nebraskans to do the same. LB369 will improve access to health care for young adults and improve health outcomes by ensuring they can receive the care they need when they need it, rather than waiting until things become more painful and costly. No young person should have to suffer with illness or injury, or even lack access to the preventive services they want because they can't reach their parent to obtain consent. Thank you.